The high stakes fight over magazine capacity restrictions just took another important turn at the United States Supreme Court. The California magazine ban challenge, Duncan versus Bonta, has essentially been sitting in a procedural limbo while the Supreme Court prepares to hear another major two-way case. But earlier this month, the attorneys representing the California gun owners, law-abiding 2A supporters, they filed a supplemental brief urging the Supreme Court to grant review to Duncan right here and now and consider magazine capacity cases immediately. Their argument was based on a massive new development. We officially have a direct circuit split over magazine bans and how states are restricting these items. And now California has responded to that supplemental authority. Interestingly, California isn't really arguing that the split currently exists on this legal issue. Instead, they're telling the Supreme Court to just simply wait and see. They're telling the Supreme Court, don't take Duncan right here and now. Instead, decide the other 2A cases dealing with rifle bans, deal with those first, and then potentially take a look at magazine bans. So let's break down what is going on with this new circuit split, what California just told the Supreme Court, and what the Supreme Court could do next on this issue. Now, before we jump into this video, if you want to support this channel, make sure to subscribe to the channel. And if you want to ensure that you get these videos going forward, make sure to turn on all notifications. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. As an attorney, and as someone who carries concealed all the time, I'm always considering what would happen if I ever had to actually use my firearm in self-defense, what would happen legally after. And that's why I've partnered with Attorneys on Retainer. Not only are they the only law firm in the nation, the only company in the nation that only does self-defense work, but also they're always expanding upon their benefits to give you as much as possible as a member. They just added in a new training division to make sure that you are actually prepared for if you have to deploy your weapon. So if you're interested, if you want to check them out, you can do so using the links down below. And if you use my code ARMSCHOLAR, you can save some money on your sign-up fee. Now, to understand why the Duncan case is suddenly back in the spotlight, we have to look back on what happened on July 17th. The en banc panel in the Third Circuit issued its new decision in the ANJ-RBC case, which was against New Jersey. And the full court ruled that New Jersey's prohibition on magazines capable of holding more than 10 rounds does in fact violate the Second Amendment. That puts the Third Circuit directly at odds with what the Ninth Circuit said in the Duncan case, dealing with a very similar ban on magazines that hold more than 10 rounds. The Ninth Circuit concluded that California's magazine restrictions could survive constitutional review. The Third Circuit went the other direction. It held that magazines are protected by the Second Amendment and rejected the idea that constitutional protections somehow disappear once a magazine can hold more than 10 rounds. The Third Circuit also rejected the historical arguments used to justify those bans. So now we have two federal appellate courts, two en banc panels, reaching fundamentally different conclusions about essentially the same constitutional question. And that's exactly the type of situation that can get the Supreme Court's attention and, could get them to grant review. Now, on August 3rd, the Duncan plaintiffs filed a supplemental brief alerting the Supreme Court of this new development and this new circuit split that has come up. Now, their argument is pretty straightforward. They are essentially saying that the split the Supreme Court has been waiting on when it comes to magazine bans now exists. The Ninth Circuit says that California can prohibit these magazines. The Third Circuit says that New Jersey cannot, and that means that Americans are now living under fundamentally different interpretations of the Second Amendment, depending upon which federal circuit court potentially has reviewed the case and what state you're in. And the Duncan plaintiffs are telling the Supreme Court that there is no reason to continue waiting. They want the Supreme Court to grant Duncan right here and now, immediately, and take up this issue because of the circuit split. However, right after that supplemental brief was filed, on August 4th, the Third Circuit stayed its own ruling while the New Jersey case prepares to also seek Supreme Court review. Now, that means that New Jersey's magazine ban remains in effect for the time being, but importantly, the state does not erase the underlying circuit split. The Third Circuit en banc's legal holding still conflicts directly with what the Ninth Circuit said in Duncan. In New Jersey, to protect their magazine ban, to keep the stay in effect, to block that ruling, is taking this case to the Supreme Court, but also similarly, they're asking for the Supreme Court to simply wait for Vermontes and the Grant versus Higgins case to be decided, and then they can address these cases or send them back down. So potentially the Supreme Court is going to have competing magazine cases arriving at their doorstep from opposite sides of the circuit split. And now California has also officially responded to all of this, and they told the Supreme Court what it thinks should actually happen, which again is simply to stall this issue. California's position is basically there is no reason for the Supreme Court to take Duncan right here and now. And California argues that they should simply wait because the Supreme Court has already granted review to two other important 2A cases dealing with rifle bans, the Vermontes case and the Grant versus Higgins case. And California argues that the issues presented in the Duncan case overlap, at least in part, with the questions that the Supreme Court will already be addressing and answering in those cases when they issue that ruling this next term. And according to California, the Supreme Court's normal practice in a situation like this one would be to simply hold Duncan until those related cases are decided and then likely GVR these cases back down to the circuit courts. So the two sides are now giving the Supreme Court two very different paths of what they want to happen. The Duncan plaintiffs are saying that there is a circuit split right here and now that needs to be resolved, and they want the Supreme Court to resolve it. California is saying you already have related 2A cases up for review. You're going to be issuing those rulings this term. And so don't address Duncan right here and now. Simply hold them and then address them later, or just simply GVR them based on what you say. And that's an important distinction because California isn't primarily responding to this new development by arguing that the Third Circuit somehow doesn't matter and that this issue, should just simply be avoided. Instead, its argument is simply a stall tactic and procedural in nature. They're simply saying there is no need for the Supreme Court to resolve this right now. Hold off, don't look at this, wait until you issue your ruling in Vermontes. However, there is a big issue for California. Before the Third Circuit ruling, the Supreme Court could look at the Duncan case and decide that there wasn't an immediate need to intervene because there was no circuit split. But now you do in fact have a circuit split based on what happened in the Third Circuit. And the Duncan plaintiffs argue that the Supreme Court should not simply hold this and make millions of Americans continue to live under these conflicting interpretations. Instead, they can resolve this right here and now and avoid the years of review and additional briefs and arguments if this case was GVR'd after Vermontes. Instead, they're saying you can resolve this right here and now. There's a circuit split. This is a very similar legal issue. We have conflicting opinions, different approaches, and this is the type of case that the Supreme Court should and actually needs to address. So now the procedural fight is very clear. The Duncan plaintiffs want the Supreme Court to grant cert right here and now because of the Third Circuit and Ninth Circuit split and divide on this issue. California wants the Supreme Court to hold the Duncan case until the Vermontes and Grant cases are ruled on this next term. And now the question is, what direction will the Supreme Court go? Do they believe that they can and should address this right here and now because of the circuit split, or are they going to take the route of simply holding these cases and then GVRing them after the Vermontes case is decided? That is the question we are now facing, and so we're going to have to keep our eyes on the docket and see what the Supreme Court does in response to all of this. So I will continue monitoring the Duncan and the New Jersey cases and the Vermontes and Grant versus Higgins cases as well. All of this is going to be intertwined and it's all going to be related. But that is what's currently going on in the critical California magazine ban case and also the New Jersey magazine ban case, which will likely impact all of these magazine restrictions nationwide depending on what happens. So as we get more information, as it develops more, I will let you guys know. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.